And good morning, Your Honor. Rita Young, P44626, also appearing on behalf of Mr. Sean Caldwell, who is present by Zoom. Mr. Caldwell, could you state your full name for the judge, please?
Did he state his name? I'm sorry, I didn't hear.
Yes, I'm Sean Caldwell. I'm sorry, I didn't hear.
Okay, now I hear you. Thank you, sir. All right, what are we doing on his cases?
Judge, as to my case, go ahead, Mr. Shimke.
On my case, Judge, the 23FB1202FY, I am now in receipt of full discovery. I would like to have a 1-week adjournment on that case so I could meet with my client. I'm also representing him on another misdemeanor case that I'd like to review with him. So I'm asking for a 1-week adjournment.
And Your Honor, as to my case, I would ask that it be rescheduled for an in-person preliminary examination, please.
Can I actually, Your Honor, real quick, can I not have this lawyer anymore? She actually left me hanging and didn't answer me and left me up running around. It's probably the reason I'm in this mess right now.
Are you referring to me, Mr. Caldwell?
Yes, 100%.
Sir,
So Miss Young is the reason you're in this mess?
Yes.
I don't think so. I'm just thinking, I don't think she was there. She's not listed as a witness. But go ahead.
Just for the record, I was appointed to represent him on January 9th of 2023. I got discovery on January 10th of 2023. I visited him at the jail on January 11th of 2023. We held the probable cause conference on January 12th of 2023, and it was set for a preliminary examination on January 24th. And unfortunately, Mr. Caldwell failed to appear, and a capias was issued. And that is why I am appearing now today.
Oh, well, that really sounds like you left him hanging.
If that's the way that it is.
Sounds like you were the one that didn't show up for the date, Mr. Caldwell. All right, so
I was there. The other person.
Here's what I'm going to do.
What?
Here's what I'm going to do, Mr. Caldwell.
Yeah.
I think you got to stop blaming people for what happened. You didn't appear, and now all of a sudden you're here. You got another case that Mr. Shemke's representing you on, and representing you on that. I suggest that you probably not cast aspersions at Miss Young, who can probably help you out and was, I'm sure, here ready to go.
Actually, Your Honor, at this time, I would move to withdraw and ask the court in Mr. Caldwell's best interest to assign my case to Mr. Christopher Shimke so that they can be handled together, please.
Here we go.
That motion is denied. I'll take it in writing, but I'm not going to do that. I'm not going to have somebody come in to make disparaging remarks so they can try to pick the attorney that they want. Both of you are fine attorneys. You guys can work well together. Sometimes if they just be quiet and just listen to what you guys have to say, you're good. But I guess he's leaving. Okay. So he just didn't want to stick around for it all. So, Mr. Shemke, you want, a week out?
That's all I need, Judge. I will do an in-person meeting and then reach out to Ms. Blanche so we have an informed decision by our next court date. Yes, please.
All right. I'll adjourn your probable cause out a week. We'll see if we can get him to stay in the room.
Nathan Taylor now?
At 9. And then you wanted a preliminary examination, Ms. Young. So I'll set your preliminary examination in that matter for the 13th, 2023 at 9 before... That'd be before Judge Washington. That ought to be fun. All right, before Judge Washington. And what we'll do is we'll have his bond continued. That way he'll be there.
And Judge, which case, was it the 1202 one that you're...
Yeah, the 1202 is being adjourned out 1 week. That's Mr. Shemke's case.
Okay.
And then in the other matter, we're setting it for exam.
Okay, sounds good. Thank you.
Thank you, Your Honor.
And Mr. Shemke, I'm sure you can talk to him about leaving the room before the court's done, but I'll let you deal with that.
Understood.
Oh, the patience of a saint wrapped in the sarcasm of a seasoned pro watching this courtroom masterclass was like seeing a kindergarten teacher deal with a toddler's tantrum. But with felony charges on the line, the defendant, in a bold yet wild misguided attempt to dodge responsibility, tried to throw the lawyer under the bus only for the judge to remind him ever so elegantly that showing up to court is kind of his job, the way the nonsense was shut down with a verbal smackdown and a yeah. I don't think so was pure poetry. It's almost like accountability was an unfamiliar concept. Good thing the judge had enough for both of them.
Your Honor, I was just going to ask for a short adjournment here. Just going to look in to see if we can get him. Sorry, I don't know why I always say here.
I don't either. I don't know. Because I guess you asked for adjournments there too.
Yeah.
All right.
Yeah, I need to request an adjournment just to see if I can get him into.
May 16th, 2024 without objection.
May the people consider that bond?
You may.
Thank you. Your Honor, at the time the defendant was arraigned, he requested a $50,000 surety bond, and that rate the defendant $6,000 surety bond was 10%. I think that the asking the court to review that for an abuse of discretion. This is the defendant's 11th or 12th OWI that we can see. His priors are from 2020, 2018. There were 2 in 2012. 2005, 1995, 1993, 1992, 1989, 1988, and 1986. And specifically, he got for OWI.
What year?
2022. The concern of the people is the rest of the public of the defendant. Professor plays on the scrum cutter, and there's been no indications that he's violated that right directions this morning. But this pervasive and ongoing history of OWI is of extreme concern to the people, the safety of the public.
The response.
Oh, Your Honor, Mr. Radke is a Navy veteran, disabled veteran from 1982 to 1985 with an honorable discharge. He's Michigan born and raised. He resides in Wayne. He regularly attends AA meetings. Last time he attended an AA meeting was yesterday, and he attended 2 of them. He also let me know that he voluntarily has looked into checking into an inpatient treatment program in Detroit. I believe it's called Life Challenge Inpatient Treatment Program. It is Christian based, and he let me know that.
How come he isn't in an inpatient treatment program now?
Your Honor, he has been going to AA meetings, and it's an up and down battle with Mr. Radke. And
I understand that, but I also understand that he served prison time for drunk driving. Was released in 2022. 21. And by 2024, I'm back here again with this. Right?
yeah, that's correct, Your Honor.
What was the alleged BAC in this matter?
Yeah, that's a really good question. We're still awaiting the blood results. This was a single vehicle crash that occurred. The defendant.
There was an accident?
Yeah, he crashed, a single vehicle crash. And the
Mr. Allen.
All field sobriety tests, all PBTs, and the blood, as the blood draw as well, and we did get a warrant. So we're still waiting on that, but we did charge the case given the history. And I will let the court know too that at the time that the defendant was booked into the Washington County Jail while awaiting medical examination, he did submit to a PBT at the jail, which was a 0.147.
That was at the time, 147 at the time of booking?
At booking, that's right, Your Honor. But of course, the court knows we won't be able to use that number for our case, but that was the PBT at the time of booking.
Anything else, counsel?
Your Honor, Mr. Radke was arraigned in front of the Honorable Magistrate Fink. I believe she appropriately set the bond here at $50,000, 10%, with a scram tether, with a no drinking, no driving standard bond conditions. Yes, there was an accident. Nobody was physically injured. He has been on scram.
We had a blessing.
He had a blessing, but nobody, from what the alleged report says, nobody was injured. He checked in today early at Community Corrections. His agent is Mr. Levitt. They downloaded they gave him a main base device for his home so he can continually test at home. He has had no issues since he's been arraigned. He is compliant with all of the bond conditions here. And he's
Counsel,
here.
you say that to me, but we're a week out from arraignment. It's a week.
I know, Your Honor, but I'm just trying to.
No, go ahead. You make your argument.
Yeah, I'm just trying to let the court know that Magistrate Fink heard both arguments. I believe she set the bond at an appropriate bond. If Mr. Radke would have known that the bond would be raised, he would have never posted a $5,000 bond that he had to use on his credit card. His son, he had to call his son here. His son is in the courtroom now. trying to take care of these matters. I'm just asking this court if it would have any leniency for Mr. Radke to allow him to continue to do what he's been doing.
Ah, yes, the classic I've changed speech, delivered with all the conviction of a teenager caught sneaking in past curfew. The defense really outdid themselves, painting a picture of a man who, despite his impressive scrapbook of DUI offenses dating back to when mullets were still in fashion, is now a model citizen. Because he attended 2 AA meetings, meanwhile, the prosecution just casually dropped a list of priors, so long it could double as a historical record of bad decisions. And let's not forget the blessing that no one was hurt in the latest crash. Because clearly luck is a legal defense now, the judge's patience here legendary. Next voice, next voice.
And get these matters taken care of, Your Honor.
I believe that given the defendant's record in this matter, given the fact that we don't have the test back, but he was almost a 0.15 at the time that he was booked in, that further that there is an accident that has occurred. Also, given the defendant's record that he had just come off parole, basically in 2022, we're back in 2024. He's done this again. This is not by any stretch of the imagination necessarily an attempt to punish the defendant, but I believe that the defendant, he may be trying his best to do what he's doing, but what he's doing right now gives the court serious concerns or pause. I don't believe that the magistrate in setting the bond, I think that there has been an abuse of discretion. I'm going to set the defendant's bond in the amount of $50,000 cash or surety bond, no 10%. I will, however, do this. Make a decision. You said that the money was paid on a credit card of some kind. I don't have a problem refunding the bond that he's paid if he needs those funds to pay for inpatient treatment. So he can be released to inpatient treatment. I'm phrasing it that I'll consider release to inpatient treatment. I'm not saying on a PR at this point, but if he needs those funds and you let us know that he needs those funds to get himself into inpatient treatment, I'm not going to have a problem with that. I want him to have help. I want him to not deal with I want him to be able to deal with the demons that face him. And I don't want him here on an OWI causing death. And I think that I need to protect the community, and that's how I'm going to do it.
Okay, Your Honor. Can I ask to approach, please?
You may.
Thank you.
All right, record should reflect that we had a bench conference just in terms of the details. And again, so that I'm very clear on the record, I don't have a problem refunding what's been paid, provided that goes to inpatient treatment.
Okay.
All right. And so I just need you to arrange that, get with the prosecutor. You guys give me an order and I'll sign off on it. Make sure if there's a cost to the inpatient treatment and you want the bond returned for the payment of that, make sure that portion is contained within the order.
Yes, Your Honor.
All right.
Finally, a judge who sees through the "I swear I've changed" routine and isn't here to hand out second, third, or 12th chances like party favors instead of the usual wrist slap. We get a master class in balancing accountability with an actual shot at rehabilitation. Because shocker, getting out of jail just to take another victory lap into another DUI isn't exactly working. But hey, at least the court is generous enough to refund that credit card bond, just as long as it's spent on something other than another round of terrible.
Case of the people versus Carla Berg.
On behalf of Ms. Bird, who approaches.
She's waiving her right to preliminary examination.
That is correct, Your Honor, and we would like to respond at the appropriate time.
Briefly, we'll be able to respond. Ma'am, you're waiving your right to preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over on both counts. Your turn.
Oh, thank you, Your Honor. I'm sorry. I was just writing that down. We acknowledge receipt of information. Wait formal reading, stand mute at this time.
Defendant in every way, formal reading, standing mute. Court will enter a not guilty plea. Pre-trial will be set for
October 29th at 1:30 before the committee.
October 29, 2004, 1:30. As to bond.
As to bond, Your Honor, my client provides that she would be able to stay at Travis's stepmother's home in Clinton Township. She gave me an address for that. Mr. Bogan, I'm sorry, Travis. Travis is no longer in the area. He went back to Georgia. I know that when we did the violation hearing, some of this stemmed on initiation of contact from him with the one of the alleged victims in this matter. He is not going to be an issue in this case anymore. She's asking for an opportunity to be out, at least on home confinement. Your Honor, she is pregnant. She advises she's not getting the best nutritional care at the jail, certainly. She provides that she would be fine with the home confinement. I'm concerned about her stress levels in the jail. I understand that last we were here, we discussed that on the record somewhat, so I'm not going to go into too much detail about that. She does have an OBGYN appointment on the 15th of November she would like to be able to go to, however. So I'm just asking for an opportunity for her to be on home confinement. Again, she's not going to have she has no problem not going to the football games. That's not going to be an issue for her anymore. The preliminary testimony provided that there was no contact between the two of them. I know that there won't be regardless. She's not going to be putting herself in a situation where Chloe could show up at a home where she happens to be at either, because she would be out of the area entirely.
Response.
I'll try to keep it brief, Your Honor. Your Honor, this court proceeded over a bond violation hearing. I wasn't here for that, so Your Honor is more aware of the details than I am. But what I do know is that there was at least 2 clear violations. Minor victim involved who is already scared, already had to witness something terrible at the hands of this defendant, already is in a horrible situation with her father because of the defendant. This defendant is a grown woman. She needs to start acting like it and stop blaming other people. She has made decisions, despite this court's orders, to go to events that are related to the school of this minor child victim. Her attitude has been very poor regarding this matter. She has not taken responsibility by way of at least changing her behavior. I understand we're in an active pending case, so she's limited in that regard. I completely understand that. But to sit here and try to blame someone else, I have no doubt that this Travis person is doing a horrible job being a father and is doing a horrible job mitigating this situation. However, we don't have jurisdiction over him. We certainly don't have jurisdiction over Chloe, the minor child involved. And she should have to be held responsible for avoiding this defendant. There is no reason she was at those football games at all. And I have little doubt that she would continue this behavior. And I'm not sure exactly if I picked up on it correctly, but it sounds like she's going to be staying with family members of the victim because that is the biological child of Travis. So I'm not sure how that would make any sense.
I don't think it's going to work. And I hear you. And I listened to Chloe and heard everything from it. I'm not even sure why this is being raised again, because it's not going to happen. Motion for bond reduction denied. Bond will continue.
Oh, what a masterpiece of legal gymnastics. Pregnancy, stress, bad jail food, and the classic, but it wasn't my fault, defense. Too bad the judge saw right through the nonsense and shut it down faster than a toddler caught sneaking cookies. Seriously, showing up at school events like some kind of horror movie villain and then acting surprised when it's a problem? Yeah, no. The judge basically said, nice try, but enjoy your stay.